Chris. No worries. We're waiting for you. You ready, Leah? All right. I'm going to call the Planning Board special meeting Thursday, October 23rd to order. October 23rd, 2025 to order. In attendance tonight, we have Mr. Kluges, Mr. Tibbetts, Ms. Wilson, Mr. Harding, Mr. Garso, Mr. O'Connell, and Mr. Lopes. We have a full quorum and a full board. All right. First up on the agenda is Chapter 405 zoning ordinance text amendments. Discuss and provide an advisory recommendation to the town council on proposed text amendments regarding the working draft revisions to the sign ordinance, Chapter 405 zoning, Article 9, specific development regulations, Section B, signs. I believe, Ms. Hitchin, you're going to lead us into this.
Yeah.
Oh, excellent. Okay. Sure.
Yeah,
Great,
if it's
Counsel.
okay, I'll just give you the quick
please do.
review from my perspective as a new solicitor here in Portsmouth. When we came in about, was it 4 months ago? One of the first issues that was brought to the attention of myself and my co-solicitor was the issues with the sign ordinance. And the history of a case that had caused some confusion as to the enforceability and efficacy of that particular piece of the Portsmouth Code. So Mr. DePiero is here. We all know the story, I think, but there was litigation over the enforcement of some basic provisions of the sign ordinance, and the ACLU got involved, and in fact, for two reasons essentially, and I'm paraphrasing and shortcutting here, but for two reasons, essentially, the ordinance was found problematic. One was a question of consistency of enforcement. There are some things that were allowed by practice, but not technically by code. And every town, as far as I know, has that same issue. There are, just enforcement priorities and levels of effort that have to be built into every administrative approach to the law, especially at a town level and especially on something like this. And then secondly, the broader issue was the question of whether our sign ordinance, as do I would say the majority in the state of Rhode Island and maybe around the country, does it conflict with First Amendment protections? So, again, I'm very much shorthanding this, but a town or a government is allowed to regulate size, place, time of installation, all those things, but it can't regulate content. And there's some subtleties to that. Commercial versus non-commercial speech are distinguished between, but the rule that we always use when we're talking to enforcement officers is if you have to read the sign to enforce it, you shouldn't be enforcing that. So it can't be about what a sign says. It has to be about, is it too big? Is it too close to the street? Is it, on somebody else's property? All those things are fully enforceable. And so Leah and I and the administration had a conversation early on when we got here, and we said, look, well, there's no point in having an unenforceable ordinance or a questionably enforceable ordinance. Just because we had one case where it was taken to court doesn't mean that it's not wrong in every case. And so what we want is to create a system so that the town staff knows what the rules are, what they're enforcing. They can do it even-handedly. And then secondly, that it's defensible even for those who don't necessarily have the resources or the volunteer lawyers of the ACLU to come and stand up for them. It's just better government to have have the laws on your books be enforceable, accurate, constitutional, all those good things. So our suggestion when we came in was, well, let's, as opposed to waiting to do this as a part of the larger comp plan review, which is a very significant process that towns have to undertake from time to time, let's just pull this piece out, move it along. We can have an excess of sort of opportunity to consider this, have some public input. We actually brought it to the council initially, sort of as a first look, not even a first reading as the law requires, because we wanted to give that extra step and just make sure that people saw what the draft looked like, what the consultants had recommended, what we've recommended. but then also use this window of opportunity to make sure we had planning board input, make sure we have public input. It was asked, and I'll mention, I talked to Steve Brown, who's the head of the Rhode Island ACLU, who I've known for 25 years. Sent him a copy of this a week and a half ago. I said, Steve, here's our issue. We had the case. He recalled the case. I said, can you send this to whomever you think is appropriate and let us know what you think, right? What does the ACLU think, so we don't get ourselves in a bind with them once we have the new one and we go to enforce it. So that's where we are. I think Leah can, talk a little bit more about maybe the consultants who the town has retained to help with the comp plan generally, but also with this redraft. Myself and Attorney Larissa, who is our constitutional litigator on the team, have also had input. And we're looking forward to hearing from, all the constituencies as to, what do you want as a town, right? We can make it legal. What we want to know, or what Leah wants to know, I think, is, what do you want Portsmouth to look like at the end of the day? Do you want billboards on every street corner, or do you want a very limited, retention of the rural characteristics? What are those points of guidance so that we can try to draft something that's suitable for your needs?
Any questions for council?
You had mentioned that you presented
You're
this
talking to your microphone.
a week and a half ago to the ACLU. I take it you haven't gotten that feedback yet. That's pending?
No. The first thing Steve asked was when do you need an answer by? And I told him the first chance that the council would have to take this up would be next Tuesday's meeting. So we may get some response before then. I haven't checked back in with him. I was giving him the time that we discussed, but I suspect in the next week or two, if the council isn't, the council's not going to take it up for final passage for at least 2 months. That's the requirement. So, sorry, for at least give or take 2 months. So, if we don't get feedback immediately, that's fine. But I expect it in the next, let's say the next week.
Thank you.
Any other questions for council? Yeah, I just have one. So the document that we have that says new section B signs, is this what was sent to the ACLU, or is it the one that the markup?
I think I said both.
Okay. All right. Great. Thank you. Anything else, sir? You good?
I think that's it. Unless you have questions, feel free to ask me at any point.
Okay. Ms. Hitchin.
Good evening, everybody. What you have in front
Can you
of you,
just tell us your name and address for the records for our listeners at home?
Leah Hitchin, I'm the town planner, 2200 East Main Road, Portsmouth, Rhode Island. Not giving my real address. What you have before you is a working draft that myself, Aaron Lindo, and our consultant Weston and Sampson have put together over the course of several months. We are pretty happy with the improvements made, but everything, like I said, is in draft right now, and I'm really looking for constructive criticism. I want you to point out things that could be improved. We think it's a lot better than what we had, but still a work in progress. So that's why I want you folks to provide comments and really take the time to look at it. So what we hopefully prepared is something that's content neutral, reasonable, enforceable, and constitutional. We have, I think probably the best way to go through this is to pull up the working draft with the strikeouts and red lines. If you can just blow that up a little. The first thing that everybody will notice is that the existing sign ordinance doesn't even have a purpose, intent, or interpretation. So we took that opportunity to add just that. The intent is to provide a comprehensive and balanced sign regulation that will protect the health, safety, and general welfare of the community, preserve the right of free speech and expression, avoid excessive levels of visual clutter or distraction, and also provide business opportunities and the community appearance that ensures signs are well constructed and maintained and expressive of the identity of the individual activities taking place. We really tried to zone in on severability, non-commercial signs, really highlight definitions, really speak to what a non-conforming sign is, as well as compliance. We talk about permit procedures and really try to button that up in this new ordinance, as well as construction and maintenance and how that must be maintained by the owner of the sign, as well as really taking a deeper dive into lighting. We often get questions about lighting and whether it is or not allowed, or what type of lighting it is, whether it is gooseneck lighting or internally lit, and we really tried to clean that up. We also go into signs allowed without a permit, really emphasize that, as well as all the exemptions for the types of signs, such as government signs, handheld signs, visual art, fuel price signs, and we did add a section about agricultural operation signs, which that's the area I really want you to focus on. We were asked to include some language that still allowed agricultural entities to have the ability to promote their business with the possibility of a feather flag. So unfortunately, this is very long, but I think the only thing I can do is to really go through it as quickly as I can, doing a high level review. So you can really see what's been strucken out, what's been added. And again, just really want your comments on it.
Why don't we go through it by section? If any board member has a question on that particular section, we can express our
Sure.
interest and go from there.
So like I said, the first thing we added was purpose, intent, and interpretation, severability. And then we jump right into non-commercial signs, which is section 3 of the draft. And we talk about how non-commercial signs, we basically lay out how non-commercial signs can lawfully continue or change, replace, or substitute, as long as the alteration does not increase the sign's area or height. The supporting structure in the physical sign is not falling apart. I say a lot. I think it's just nerves. Trying not to say we clarify in section 4 some of, or many of the definitions, although some of them still remain on page 2 of the list. You'll see that we even tried to include examples and illustrations of what we mean by sight distance triangle, so vehicles and drivers can properly see the visibility and safety of motorists and pedestrians. So we thought that that illustration was pretty helpful.
It is, and I do have a question on that. Is there, like specifically you're on a state road or state highway, are there already regulations that govern sign placement in those locations?
It basically speaks to the same that we illustrated here, where it just has to be kept back out of the town out of the state or town right away, so you can physically see without having to pull into traffic.
Got it. Thank you.
We didn't change anything on the definition of a sign banner, but one thing that was missing that really needed to be defined is electronic or digital signs. We have received requests from the high school, a local church, to convert their signboard that you physically install to a digital or electronic sign. So we wanted to really identify what that consists of, that they're still not allowed, as we want to keep the coastal historic aesthetic that we have in this community. Another large definition that we added is off-premises signs, which weren't super clear in the original ordinance. And that sign is located on a lot that is not in common ownership with and lacks a direct functional relationship to the principal use of that lot. Another one we added was advertising structure or outdoor billboard sign. Portable signs, which are signs that are often seen on a box truck to advertise for a company. We put a little additional information in what a temporary sign is, which are often important around political season. A banner, pennant, poster, or display constructed of paper, cloth, canvas, plastic sheet, or like materials, but we added specific time frames that are intended to remain in place for 90 consecutive days or less and no more than 120 cumulative days in a 12-month period. Anything beyond that, then it becomes a permanent sign. And then jumping down on page 5, we add the definition of a permanent sign. We also include yard sign definitions, which are temporary signs for yard signs are temporary signs for all enforcement purposes, duration and maintenance. And then we go into like what actually is in our view a yard sign. Moving on to section 5, existing non-conforming signs, we are allowing them to remain. When we get down to section 16, we are putting in like a sunset clause where after 3 years, a non-conforming sign has to be removed or updated to conform to the correct standards that we have written in here.
And Leah, I'm sorry.
Sure.
I was just gonna ask Leah, can you just clarify, that's for a sign that's permitted, but it is now non-conforming
Correct.
under the ordinance, not unpermitted signs?
Correct. That's correct.
We have a sense of it that's fit to business owners in Portsmouth, but to the extent that people are not conforming, that this is nothing for. We already kind of have that little fair part.
Right. Mm-hmm. I'm sure there are a couple of non-conforming signs that either the property owner is aware of or is fully known that it's non-conforming. We might have to, I'm asking for advice on how to let that be known. I'm happy to take in any comments, but we really want to focus on an amortization and sunset clause to remove any non-conforming signs that currently exist. Given 3 years is a decent time period.
Probably the life cycle of your average sign is around that anyways, just for normal replacement, repainting, whatever that might be. And Leah, there's not a dimensional, there's not significant dimensional changes, right? We're not saying that you have to go from 100 square feet to 50 square feet.
Absolutely
in the
not.
ordinance. So it's not like every sign becomes non-conforming if we pass this. It's only things that were already violating the current dimensional, for example, dimensional requirements of the ordinance. So it's not taking something that's been there for 50 years that was completely, permitted and fine and saying now it's not fine.
And if a property were to change ownership or use, that non-conforming sign would no longer be allowed and have to be removed. We, in section 6, the new section 6 is compliance, and we really tried to focus on when a building permit is allowed or exempt from building permits, or how to go about properly getting a permit for a new sign. So that goes into section 6. Again, we talk about construction and maintenance and when a sign needs to be replaced, such as the supporting structure is no longer functioning or broken or is in need of repair. And that the area surrounding the general sign in general needs to be kept free of refuse, litter, weeds, overgrowth, and any other accumulation of materials that could present a public nuisance. We tried to expand upon materials for permanent signs, as well as materials for temporary signs, which is in section E here. And then, like I said earlier, we tried to really add a large section on lighting standards and when a light can be added to a sign, and illumination limits, times, hours of operation, and stuff of that nature.
I did have a question just going backwards. On feather flags, that was under materials for permanent signs. That's saying that you shouldn't have any of those things on a permanent sign. Is that what that means?
Yes.
Okay, thank you.
The next section is we expand upon signs that are allowed without a permit. Those include government signs, beware of dog type of signs, fire lane, no parking, temporary signs, and portable signs. And we have a new table that explains what the sign is, the maximum area, maximum height, and the amount of time that they can stay on a property.
I just had a couple comments on that, because I am in the construction business, but like project signs for construction, et cetera, typically a lot of that is sized to fit on temporary fencing. So maybe you could take a look at that, because I don't know if 32 square feet would fit the kind of the bill if you're trying to do some type of temporary fencing, especially if you're driving by, that's not very much space. I'm just curious what other towns do. But
Okay, we
typically
can,
vendors and contractors that are on a construction site, they try to conform to the fence, size of the fence,
Mhm.
because it's easier for them.
what do you often see when you're working with construction signs?
So for instance, a lot of times you can buy banners that you roll up banners, but they're actually the size of a 6x8 piece of fence,
Mhm.
so that you can actually put it on that fence so that it conforms to typical construction fencing. That's all. What's that?
It blocks people from looking.
Yeah. It also kind of helps stop the visual,
Mhm.
if you got things
Rubberneckers.
behind it. Exactly. Yeah.
I also have a question on, before you were talking about, not so much beware of dog, but no parking. What type of sign it could be, like if it was a metal sign, that it should be at least, the height should be at least 7 feet. Only because when you have a metal sign, someone can come and hit it square on and because it's a metal, can definitely be damaging to someone.
I'm fine with 5 feet.
That's a good point,
I
Kate.
know, but this is,
Understood.
I get it
understood.
from the MUTCD and highway and
Mhm.
certain signs, breakaway. So if something is a fixed object, between non-breakaway, use of signs that should not be put on utility poles.
Mhm.
Yeah, and the height of certain signs, especially if they're made of metal.
Okay, I understand that point. I think it's a fantastic safety perspective.
I can get you the MUTCD paragraphs. I don't have it in front of me, so I can.
That's the manual and uniform traffic
Yeah.
control devices.
Well, I'm studying for the PE. Believe me, it's like, oh, yes, I'm 7 feet.
Nobody else knows that.
Yeah, I know, sorry.
Thank you, Mr. Lowe.
Thank you for that clarification, and we'll definitely look at that. So moving on to exemptions. This is a whole new section where we tried to outline as best as possible the exemptions that are allowed from the sign ordinance. Obviously, government signs, which have always been exempt. Machine integrated signs, automatic teller machines, signs that you'll see at a vending machine or fuel pump that now change the cost of for a gallon of gas. Address markers have always been exempt. Visual art, work of art, is exempt. Expressing personal, ideological, or political views are not regulated as a sign under this ordinance. Flags, we really wanted to take a deep dive into types of flags, whether it be a feather flag, American flag, a flag that changes with the seasons. We did include that. And then this goes into agricultural operation signs, where we spoke about what is allowed specifically for agricultural operations that fall under the Right to Farm Act as being exempt from the permit. We do include information about where they can still be located. The size and height must still be maintained. Number of signs allowed for an agricultural use, as well as illumination. Now, this may be a little different from what other communities have in their sign ordinance, but we do specifically call out that feather flags can be one of the 2 allowed signs per frontage, maybe a fabric feather flag, as long as it does not exceed 15 square feet in size, where the flag itself is no taller than 12 feet. It is displayed only during hours the farm stand or agricultural business is open, and is set back at least 10 feet from any lot line and outside all sight distance triangles. That's something we heard from certain businesses a few months ago, that they'd really like to see some continuation and visual need that they need for their farms. The next section is signs prohibited.
Hey, so I had a question on the fuel signs.
Yes.
So it says a sign is static and may not scroll, flash, animate, or alternate between multiple messages. Does that mean that a sign that says member and non-member pricing, that will not be allowed anymore?
See, that's where I'm really looking for input from the planning board. And again, once it gets to the town council, is most of those type of signs already change on whatever time frame they have. And those would be exempt.
Okay.
Is that's if it changes every day, that's not viewed as alternating but if it-
Correct.
If it changes member, non-member every 10 seconds,
I got it.
that's alternating.
I got it.
And that would be
What-
prohibited, right? Is that?
Yeah, what we're trying to exclude is oscillating digital signs that just constantly
Sure.
run
Could be
and
distracting.
can be
Yeah,
distracting.
yeah.
Moving on to prohibited signs, we talk about off-premises billboard signs, electronic or digital. Projecting signs with internal illumination. Right now, our current ordinance allows signs for internal illumination. And we really wanted to clean that up as to what is and what is not allowed for internal illumination, and we're trying to strike that out of the ordinance. Any signs attached to a utility pole, any sign that could be mistaken as a traffic sign are not going to be allowed. We go into signs allowed in residential districts without a permit. I feel that's pretty self-explanatory for identifying a subdivision name or to that.
I just had, I had another note here going back, so on signs prohibited. So if a business has a sign out front and say they're only open on weekends, are they allowed to put an open flag, like on the post outside their
Yes.
place? Okay.
Mhm.
Okay, thank you.
Sticking with, signs prohibited, the item J, just, you know, I'm thinking to the, allowed by practice, not by code enforceability. And most of everything in here is pretty straightforward, sizes, shapes, you know, relative to, but that J just says signs which by reason of size, type, or location hinder or distract the vision of drivers or detract from visibility or effectiveness of any traffic sign or control device. I don't, like, I read that a couple times, and I'm like, I don't know if what's visually distracting to me is the same as you, and then I get into a little bit of what's subjective, and not sure how to enforce that necessarily.
Mhm.
I can tell you what I think is visually distracting and gonna make me pull off to the right, but I don't know if that's enforceable.
What do you think on that, Gio?
Yeah, I think that section is typically used more to prevent things that are directly, you know, physically obstructing a traffic signal or a directional signal or a street sign, you know, things like that. I don't think this is meant, you know, to be applied.
So, I mean, maybe clarity in that respect then, because I'm reading it this as maybe something else. And I
Okay.
see there's clear language in here on, you know, like that, what page 2 visual you have is, that's the helpful kind of, that's very clear guidance. So.
All right,
I didn't know how to interpret that.
Okay, we'll highlight that as something to further look into, and possibly modify it. Would that be helpful?
Yeah, yeah, it
Okay.
would help me. I don't know if it helps.
Okay.
I don't know
Yeah,
if
that's
everybody
a good
else
point.
understood it.
It's a good point.
We talk about signs allowed in residential districts with a permit, temporary signs, on lands actively being developed, like, Mr. Lopes has brought up, and we give specific timeframes when they need to be taken down. We talk about signs, specifically signs allowed in commercial, industrial, and waterfront districts with a permit. And it specifically notes the type of signs and how large the area can be, for just saying one freestanding sign not to exceed 15 feet in overall height, including the space clearance between the ground and the sign. In instances where a lot has more than one street, only the frontage on one street may be used for calculating sign area. Many properties in town have basically like a plaza where there's more than one business on the lot, and we have identified that as a common signage plan, which contains, specifies standards, lettering, graphic, lighting, for those type of properties. And the requirements is laid out in this ordinance. We also go into signs permitted by special use permit or dimensional variance. That's laid out. We added a whole section on the administration and enforcement of the signs, saying specifically responsibilities of the building official, zoning enforcement officer, when a temporary sign becomes a permanent sign, standards for enforcement procedures, how to appeal a sign situation. And many times throughout this ordinance, we talk about content neutrality, and that everything is based solely on the physical, structural, or locational characteristics of the sign and not message content. This is the area that I also talked about earlier with the sunset clause for existing non-conforming signs. And we specifically say that any permanent sign that was lawful on the effective date of this ordinance, hopefully it passes at some point, but does not conform to the new dimensional height, lighting, or location standard shall be removed or brought into full compliance within 3 years of the adoption date of this ordinance, unless a shorter period is imposed as a condition of a permit or approval. So that's something new. And I guess my question to you is 3 years, 3 years enough? Will the general resident want to see less of time for sunset clause?
Anybody have an opinion? I think the solicitor's definition about the longevity of a sign was pretty accurate.
Pretty on target, yeah.
Signs typically last, but it sounds very plausible that, after 3 years, you got to do something with it anyway.
I think at least
paint
maintain
it,
it. I mean,
maintain
of
it,
course, it
do
depends
something.
on, a big metal or plastic sign is going to last a lot longer than 3 years. But,
Mhm.
we're talking about ones that may be already in their life cycle now and
Sure.
things that are painted or made of, something other than that sort of permanent material, wood or something like that will have at least maintenance requirements.
Right.
But you said you could still get an extension anyways.
There's a possibility, yes.
Yeah.
So we don't rule out anything, but there is an avenue to take if somebody needs an extension. The last section that we added, and I apologize for going through this really quick. I just want everybody to really read it themselves and see what they say. But we do have design guidelines that do talk about types of signs and the aesthetics. And when properties are located within an overlay district or a planned unit development, those signs do get reviewed by the design review board, and we'd like that to continue. I inadvertently added in this historic districts, and I think that's my internal thing of hoping that one day there are historic districts in town, so we can actually strike that portion out. And that's the high level review of 22 pages that I just presented. I guess I'm again looking for comments. At one point, we will provide an advisory opinion to the town council when they review it in the upcoming months. So that's where we're at right now.
Mr. Chairman, can I just ask Leah one
Yeah,
question
yeah,
for
please.
clarification before the board does? Leah, and I apologize if this is in here and I've missed it, but this has come up recently at the ZBR. On page 17, we've got a provision, and I'm sorry, because every time I look at this, I find new questions, no matter how many times I look at it. So we have section C at the bottom of page 17, where it references, I think it's the first reference to a lot upon which is located more than one establishment.
Yes.
That question came up with the zoning board because what's an establishment? If a tenant sublets their space to 5 businesses, is that 5 establishments? Or is it, if you have a lease with the landlord, you're an establishment? But if you have, 20 realtors in an office, maybe they're leasing a desk. Is each realtor an establishment, or is the realty firm an establishment? And I think I haven't seen where we clarify that.
No, and that's a great point. We get those questions on some properties in town, and you obviously got one for the zoning board.
Yeah.
We could definitely add language in there that specifies that sort of
Or a
thing.
direct contractual relationship with the owner, maybe, or
Yeah.
some version of that.
Well, it's typical in real estate. You might see a main firm, but then there's specific teams underneath that.
Yeah. And I think they're allowed to list that on their sign, but
Yeah.
they have to do it within the square footage they're allocated,
Okay,
right? Not every team gets their own
right,
square
right.
footage allocation.
Understand.
And I think that's what we're trying to avoid. You could have, somebody would get 20 times as much signage as their neighbor if they had 20, teams or whatever that might be.
Will that hold true in typically we've got some areas where the Neon or Patriot Petroleum, so they sub-license places in there. Are they limited to one sign now too?
I don't know. I'm not familiar with that. Hasn't
That's
come
just
up yet.
something to think about.
Yeah.
I mean, definitely, I'm writing it down.
Okay,
And again, if a mothership business has 3 sub businesses, right? They they can list all of those, but only on the signage they're allowed. So if you have a petroleum, business and a gas burner repair business and a, tank removal business, that's, you can advertise those separately, but you just don't get more space for
Got it.
So like a tradesman center, it would be one big sign and everybody who's got a space in the tradesman center has their allotted wedged, and that's the only way it's visible, right?
Yeah, I mean, you'd have to sort of
Right.
decide how you want to do that, right? So if it's like commercial condos, I assume
Right.
each of those condo owners would have their own, those would probably be defined as individual establishments. So they would each get their own sign. But if within one of those commercial condos, I've got, my 7 cousins, and we all have separate, LLCs,
Right.
we don't get 7 signs, we just get the one.
But a lot of times, say where my shop is in Middletown, there is being repainted right now, a big sign that lists all of the tradesmen centers that are in there. And then when you get to your building, you have signs on your
Yeah.
building itself.
And I think we have directory signs separately
do.
permitted, right? So that
We-
the
Okay.
common sign ordinance, which is the next section, allows for the directory sign that can list 50 tenants.
Okay,
So somebody can find you, right?
thank you.
The Amazon driver knows where to drop the
Yeah.
package, right? That's the biggest issue.
Anything else, Gio?
Thank you.
Anything from the board for Ms. Hitchin? Go ahead, Mr. Tibbetts.
One general question. You mentioned, I think maybe I heard 3 names of, you obviously put a lot of work together into putting this draft together. I'm sure it was grounded in the original one. Was there anything else that we look at other municipalities that have recent signage plans to draw off of any good inputs that they had that are still consistent with what we want to achieve with our own character?
We looked at like every sign ordinance in the state.
I assumed you had done some of that. I just wanted to get that on the record because I don't know.
And out of state. because
And- yeah.
The consultants do work outside Rhode
Mhm.
Island, and so you
Right.
get the benefit of that, and we consulted cases in other states that would have been litigated on the First Amendment issues, on a variety of issues.
Right. Thank you.
I can say that for the record. We did a lot of research.
I just, that didn't come out of this, and I'm assuming that, I mean, that would have been the smart thing, is I always like to plagiarize first, where I can, where it makes sense, and particularly with towns that have more recently gone through
Mhm.
their own revisions, so, thank you.
Go ahead,
Yeah,
Lou.
how about like parts of town that could only have certain signs, like Bristol, on Hope Street? All the signs, you can't have like a McDonald's sign. It's like they have a Dunkin' Donuts, but you would never know. There's no way of knowing that that's a Dunkin' Donuts other than reading it. So there's certain parts of town where the towns have to be, the signs all have to be pretty much all the same under control, but other parts of town can have the regular Cumbie sign or whatever is there. Is there any?
I think you're for Bristol and that main historic district, there's probably specific regulations for their historic district. We don't have a historic
Yeah.
district. So I guess I'm not sure what,
I just didn't know if they're making any parts of town limited to having a consistent sign.
no.
So you don't go down the street and it looks like. I remember-
We break it out into residential versus commercial, industrial, based on the zone.
Anything else from Ms. Hitchin?
Yeah,
Yep.
Lee, I have a general question. Is there anything in the regulations that tells about the density or the number of signs in a particular acre or quarter acre or whatever it is?
It's not based on acre, it's based,
On a square footage.
it specifically, calls it out.
Lot frontage, right? The
Um,
size is based on lot frontage, I thought.
on page 16, signs allowed in commercial, industrial, and waterfront districts with a permit. And it goes into detail about how many types of signs and the maximum square footage that can be allowed.
Does that answer your question, Mr.
Yeah.
Cookies? Okay.
Thank you.
Anything else for Leah? Okay. Thank you. I'm going to open the hearing up to public comment. If you have nothing else.
I have
please.
nothing else to say, just waiting for more questions and I'll
Okay.
be happy to answer.
All right. Please, if you have a question, please come up to the podium. State your name and address for the record, please.
Mike DiPaola, 236, one second, drawing blank, Dexter Street,
Got it.
Portsmouth, Rhode Island.
All right.
Again, who is she to tell me
Just-
if it's my real address or not?
Just continue, please, sir. You stated your address for the record.
I filed with the town my address. Whether they want to accept it, not accept it, that's their problem.
We take you at your word.
Okay. Second thing, Gio, am I allowed to speak at a town meeting? Because last time at a town council meeting, I was told that I was not supposed to speak at any town meeting. I'm just,
Please.
So,
Yes, you are allowed to speak at a town meeting as long as it's relevant to the topic at hand.
absolutely, okay. First of all, we all know why I'm here. Second of all, this 3-year lifespan on a sign, to me, that seems very arbitrary. I have commercial strip mall. I've had my big sign for the plaza up for 25 plus years. I haven't changed it. I changed the slats to follow the rules with the town of Tiverton. And it basically just, you're changing the names, but the actual sign itself hasn't been changed for over 25 years and it'll probably still be there for 25 years more. So I don't know where this 3-year lifespan came up with. I think it's very arbitrary.
Lifespan was just my comment. I don't,
Okay.
that's not in the ordinance. So
Okay.
I'm sorry if that was confusing. I was just trying to give a sense that, signs need to be repainted, they need to be updated, slats changed, whatever that might be. But if your sign is compliant, then the 3-year limitation for reversion to the new standard does not apply.
Okay. As far as when the town issues a permit for a sign, the town issues the property owner submits a plan. The town doesn't enforce the setbacks on a property that I'm specifically speaking to on East Main Road. It's set too close to the street. It's literally 3 feet away from the street. I know because somebody called on my property on East Main Road and they told me that I had to be 15 feet or 25 feet, 35 feet, whatever it was from the center line. So I had to push some of my stuff back. This property, the sign was issued by the town recently, within a year. It was too close to the street. I reported it to the town. I reported to zoning, and they told me that it's allowed, and if I have a problem, I need to contact the state because now it's in violation of the state setbacks. But the town approved the sign.
yeah,
So at what point does the town take responsibility saying, hey, you know what? I made a mistake. We need to get this corrected. We allowed this to happen. It was brought to our attention, but instead of disregarding and looking the other way, we need to take care of this.
Mr. DiPaola, can you keep it relevant to the
Yeah, so-
amendments to the sign?
Well,
ordinance?
that's as far as the setbacks and everything else. That should be part of it. Does it go back?
So we're charged with making an advisory opinion over what's in front of us right now.
Okay.
What you're citing is an enforcement issue. So that's not us. That's something you'd have to take up with
But
with
it's,
the council.
it goes back to the enforcement portion of the new sign ordinance. That it's required by the building official and the zoning officer. If I'm correct, the zoning officer and the building official who issued the permit for the sign should be enforcing it.
Yeah,
Well, there's
go ahead.
language in the new,
So this,
there's new language that talks about enforcement. And so do you have an issue with how the new language would
So does-
be implemented? I'm not sure what.
I guess I guess I'm getting confused. If there's an issue on the current sign ordinance violation, if there's a violation,
We're not asking about that. We're asking about the language in the new ordinance. Are you
so does
concerned that we
anything go
don't have
back
enough
or it
enforcement?
only goes forward?
Only looks forward. Yeah, I mean, we're talking about looking forward here.
Okay. What's the definition of visual art? As he said, Mr. Tibbetts, you said there's distracting signs, right? So somebody might say it's distracting, but you might say it's not distracting.
and that's, we asked the question. So I think we're going
So visual art is all subjective.
And I think that was Mr. Tibbetts' point was,
Same point I made in.
Correct. So
discussions with
somebody's
taking-
visual art maybe, I don't know, they don't like it, but it might be beneficial to somebody else. Also, the freestanding sign plaza.
And then just not to interrupt you, I apologize, but, and then I took the visual art, correct me if I'm wrong, as something even different, because the visual art isn't regarded as a sign, it's exempt. Thank you.
But the location of it is still
Still
regulatable,
relevant.
right? You can't put a Michelangelo's David on the, you
On a
know,
telephone pole.
on the corner to block, the traffic view, for example.
Okay.
Okay, we'll go back to the freestanding sign, one per plaza. There are a couple of locations that I know of, one on Raytheon and one on Sandy Point Road, where as you go into the property, they have a sign to the right as you enter, they have a sign to the left. So in the driveway, as you enter those two properties specifically, there is a sign to the right and a sign to the left. So one of them is gonna disappear, and on the one on Sandy Point, there's a third sign for the school. That was never issued a permit. But I'm just saying, how many of those signs are allowed? Because the old one and the new one, so you're gonna make them comply at some point with 3 years. They're gonna limit one sign per plaza. That's what the new one
The
said.
common signage plan in a plaza is more than one sign, but yes, they shouldn't have
They
two
should have-
landmark signs.
Correct. So when you drive in, you can't have a sign to the right that says Raytheon. If you're coming from the north, you see the Raytheon building on this side. And if you're coming from the south, you see the Raytheon building to the left. You can't have two at the entrances.
I without getting to the details of the current issue you're describing, which I'm just not familiar with. If somebody is out of compliance once this passes,
Correct.
then
3
they
years.
have,
years.
they have 3 years to either get if there's a special use permit they could get, if there's some waiver they could get to allow it, that's one approach. If they don't get that permission, then they have 3 years to remove it and comply.
okay,
That's it.
okay,
Thank you.
thank you. Is there anybody else in the audience who'd like to speak on this ordinance? Please, state your name and address for the record, please.
Good evening. My name is Steve Anderson. Address is 234 Headley Street, Maplewood Farm. Earlier this late spring, I was one of the farms that was targeted. And the removal of our swooper flag affected our sales. I came in front of the council and spoke to them and told them how much it affected. I moved them back. One of them is on state property. My grandfather, I am a third generation potato farmer. I also had to explain to my aunt, an 82-year-old woman, that I had to remove our flag and our sign that has been there for generations. A couple of you are our customers, that's fine. I'm asking that farmers be exempt from all signage. Because there's only a handful of us left. I'm not sugarcoating it. I'm asking farmers to be exempt under the right to farm and forests, if I'm not mistaken. Farm, forest, open space. It's a tongue twister there. I'm not sugarcoating, including the wineries and breweries, which have seasonal, and they do their weekly events. So they'll put their own little signs up, and most of them take it down. So I'm asking the farmers and breweries or wineries, I don't know how many there are, but there's only a handful of us left to be exempt. Thanks.
Thank you.
Any questions, or should I just, am I good?
Were there any questions for Mr. Anderson?
Specifically requesting that these type of businesses be exempt entirely.
The farmers, and the farm breweries and the
from the sign
wines.
ordinance.
Correct, because there's only a handful of us left. And it affected our sales. I mean, developers are offering quite a bit. And it's, how many more farms you want to lose?
I know there's a specific section here for agriculture, right?
I know.
Yeah.
I know. but I'm asking for the farmers.
Sure, so I think we've heard what you're having to say,
Okay.
and we'll take that under advisement, with the planning board.
Hope I didn't sugarcoat it.
No, you didn't, sir.
All right, thank you.
There is discussion here on agricultural operation, general laws, right to farm act are exempt from the permit, area counters. But I don't, I'd have to dig into this deeper
Yeah.
to figure out what are those exemptions?
That's
mean?
all right.
That's
That's
my-
why I'm here. I'm
Okay.
digging potatoes, so I'm a little tired, so.
I used to do it too, sir, so I know where you're coming from. Thank you.
Thanks.
Anybody else would like to speak on this ordinance? Is there anybody online?
It's just, if there's anybody that would like to speak virtually, raise your hand and we can elevate you. None noted.
None noted, okay. So I am going to end the public comment portion. It sounds like, Gio, you said we've still got comments that haven't come back yet, or potential comments.
Yeah,
Sure.
I think there's, you know, our goal in putting this out here and having it in multiple forums and reaching out to groups like the ACLU who have opinions on the speech components of this, is to allow the maximum input. And, you know, these ordinances are very important to towns,
Sure.
and it, you know, can change the character if it's not thought through and enforceable and all that. So yes, there's a window of time. I believe, I don't believe the agenda for the town council for this upcoming meeting on Tuesday includes any review of this. Is that right?
That's
Yeah.
correct.
Yeah, so it won't happen at this meeting, but at some point soon thereafter, we'll have the first reading, which is when the town council receives, you know, a working draft. It's an official acceptance of that. And then they have a public forum and a vote at the following meeting or some following meeting after advertisement. So
Okay,
I think we've got a, you know, 6-week to 2 or 3 month window, you know, for feedback, but I would encourage people who have written comments or obviously this board, the town council wants feedback from this board, that it be done in the promptest way possible, because, you know, you have to take that in, you have to talk to consultants, you have to sometimes research the legality. You know, even the farm, forest and open space question, I've looked at it. There's some technical issues that would have to be sorted out on that front if we tried to create an exemption. So, you know, it's not the kind of thing we want to hear about, you know, 2 days before the meeting or at the
Sure.
meeting when it's up for approval, because that just slows things down.
so I know we've got a lot of information. We got public comment to consider. We still got legal questions that are coming back to us. So I think maybe the appropriate thing is we'd entertain a suggestion to, or a motion to continue this to the November 13th meeting, which I think is our next scheduled meeting.
That's correct.
Okay,
Can I
Yeah,
ask?
please, go ahead.
The public comments, is that scheduled yet?
No,
The public meeting?
no, we haven't even
Our
submitted it to the council.
recommendation would be notwithstanding, you know, obviously additional consideration from the public at that forum. If we did make a.
You are addressed with creating an advisory
Right.
opinion to the town council. Based on some of the questions that were asked tonight, some of the legalities, not having the ACLU comments back. And obviously I have to do a little bit more research on some of the things you pointed out. I'd like to keep this meeting going to the November 13th meeting, and I can edit based on things you've suggested. But like Gio said, we're trying to give everybody the maximum amount of time for public input.
so by continuing it, we keep the meeting open
Right.
until the 13th.
And there was something I saw or discussion about getting this to the town council or by within 45 days. That's not an issue with continuing this, correct?
I think to properly do this, we need to keep it open as long as possible.
I would think just process wise, there's no ideal answer to what the process is, right? Because no one wants to say, here's our advice, and then see 3 more iterations come out before the final vote, right? Because now you're going to say, well, we didn't hear from the ACLU, or we didn't hear from
Right.
the historic preservation folks before we gave our, you know, there's a
Yeah.
lot of moving parts. So I think the only way to make it work is to say, okay, you know, here's the latest and greatest. give us your feedback on this. And so maybe between now and November 13th, the individual members can provide commentary to Leah, and she can incorporate it into a proposed memo that you would then approve at that meeting,
Okay.
right? But if you're still waiting at that point, you may just lose your window to comment. And I hate to see that happen, because at some point the town council is going to want to act.
Right,
It's been-
and to your point, to Mr. Tibbetts' question, we'll provide an advisory opinion. The council can still make changes at that point.
Yeah.
And you all have the absolute right to go in front
To
of the
the
council at that public hearing and say,
Correct.
we stand by our advisory opinion, but since you made this change, here's our opinion on that. Here's my
Sure.
personal opinion on that. So you don't lose that right just by cementing an advisory opinion. But what you do is you make the staff's job incredibly easier by letting them know what your concerns are now, as opposed to waiting until some
Sure.
future date. So.
Okay. Thank you. Anything else?
I
Leah?
guess I'm just curious, with the very high level review that I provided, do you think it's coming together? Do you find that it's more reasonable, enforceable, constitutional than the previous existing ordinance?
Just my own opinion, I thought it was, based on the previous, I thought it was much more readable. It was clear, it provided clarity. I thought you hit all the points. I made those comments tonight. Those are from my first reading of it. So I'm satisfied with what you've done. I don't know what other board members have to say.
I agree. And that's why I was asking the questions, because it's clear there's some work went into this, and I appreciate that. And, it's good to know that it's also nested in trying to take the best elements of what other municipalities had as well.
Thank you.
So I think if there's with the pleasure of the board, I think that we should have a motion to continue to November 13th.
Yes, I'll make a motion that we will put this till the November 13th.
We'll continue it to November
Continue it to
13th.
it.
Okay, we've got
And yeah, hopefully we'll hear what the ACLU and had a little bit more time to digest this, but I definitely think it's in the right direction.
do we have a second?
Second.
All right, motion made, seconded by Kate. Any discussion on the motion?
Mr. Chairman, I would just add that if any of the members have specific questions, I mean, obviously Leah's here and capable of answering, but you're also welcome to email me directly if there's something you think is a legal question or that you should look at. Again, rather than waiting to raise those questions on November 13th, I'd rather have a chance to either answer it and dispose of it, or hear the question and research it, so I can come to you with a solid answer at the next meeting.
Thank you. That's very helpful. Okay, let's take a vote on the motion. All in favor, say aye.
Aye.
Aye. Any opposed? Motion carries.
Thank you,
All right.
everybody.
Let's have an adjournment.
Motion to adjourn.
Mr. Harding, seconded by Mr. Tibbetts. All in favor, say aye.
Aye.
Aye. All right. Thank you.